Next case set for oral argument is case number 28969. Richard Baab versus Medina City School Board of Education. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. I'll keep track of the time, so let me know if you want to reserve any time for rebuttal. Please keep your voice up as these are being recorded and posted on the court's YouTube channel. And because we record and post these arguments, the court asks that you refrain from using the names of children or victims in your presentation. So just use initials if you would, please. We've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. May it please the court and counsel, my name is David Hurd, and I represent the Medina City School District Board of Education and one of its guidance counselors, Julia Schwendeman. I would like to reserve 3 minutes for rebuttal.
Okay, very good, thank you.
This case arises from a horrible event, the self-inflicted death of a teenager. And I think that it's human nature in a situation like this to number one, try to find out a cause for this tragedy, and number two, oftentimes to assign blame for what happened. And so what this case is about is that Ohio law, as tragic of a situation as it is, Ohio law provides that Julia Schwendeman, one of the board's guidance counselors, is immune from liability per the General Assembly because she did not act recklessly. And that is really the focus, I think, of this case. And so the primary issue is, was Julia Schwendeman reckless when she did not tell Mr. Baab about a phone call that she received from another parent, Kim Mahoney? And if she wasn't reckless, then that exception to her immunity doesn't apply. And the two claims against her that weren't dismissed should have. The trial court in this case quoted extensively from the O'Toole case, the Supreme Court case, when it kind of set the stage as to what was needed to show that Julia Schwendeman was reckless. But unfortunately, what the trial court then did in its application was that it terribly misquoted and misapplied the definition of recklessness for the Supreme Court. And I think that it's worth a little bit of time to go through a little bit of that misapplication, because that's what your task is at this point now, is to evaluate what the evidence is and to decide on your own from scratch whether or not there's evidence to suggest that Julia Schwendeman was reckless. So on page 7 of the trial court's decision, it says that a reasonable person under this fact pattern could recognize that failure to act or report additional incidences could result in DB's death. Well, that's not reckless. To use the word could result in DB's death is not what O'Toole says. O'Toole says that there have to be facts known to the alleged reckless actor that would lead a reasonable person to realize that her conduct creates an unreasonable risk of harm. And so when the trial court says, well, the facts could have led a reasonable person to conclude that DB could kill himself, that's not reckless. And so that's one way that the trial court completely misapplied the definition of recklessness. Also on page 7 of the court's entry, the court says that there are facts in the record that could support a determination of conscious disregard for a known or obvious risk. Well, that's not reckless. Conscious disregard for a known or obvious risk is not recklessness. Recklessness, per O'Toole, requires a perverse disregard of a known risk. And I'll try to explain what I believe is the difference between those two. But the court saying here, the trial court saying here, that the facts could support a determination of conscious disregard for a known risk, well, that's not recklessness. When I drove here today, I consciously disregarded the known risk that I could be in a car accident. But that's not, getting on the interstate is not recklessness. There has to be a perverse disregard for a known risk. And what makes the disregard of a known risk perverse, as opposed to just knowing about the risk? Well, that's the other part of recklessness that the trial court also failed to apply, is that to be reckless, The proposed reckless actor herself has to be conscious that her conduct will, in all probability, result in injury. And so that's really the question for the court is, did Julia Schwendeman know, was she conscious that not telling Mr. Baab about Kim Mahoney's phone call would, in all probability, cause DB to take his life? And not only is there simply no evidence of that, the evidence is strong to the contrary. So I think what you need to do is look at the conversation, the communication between Julia Schwendeman and Kim Mahoney. And so here's what is in the record. Julia Schwendeman was asked numerous times in her deposition about what was the information that Kim Mahoney relayed to you. How did you interpret that information? And she adamantly said more than once that what Kim Mahoney talked to me about were things that threats that DB had made to his friends in the past. And these were things that the evidence is also undisputed that Julia Schwendeman had already talked to Mr. Baab about. That was the reason for calling Mr. Baab into the school on the 31st. That was the reason for Mr. Baab taking DB to App.No Children's for a risk assessment. And so the evidence from Julia Schwendeman's testimony is clear that her interpretation of what Kim Mahoney was saying were all things that she had already spoken with to Mr. Baab about. And it's also important when identifying what Julia Schwendeman was conscious of when and after she spoke to Kim Mahoney. It's also important to realize that not only did Julia Schwendeman know that professionals at App.No Children's had already decided that DB was not a suicide risk, but Mr. Baab had told her that he had an appointment for counseling set up for DB in the middle of November. And so that this is precisely when the conversation between Julia Schwendeman and Kim Mahoney.
But I'm sorry for interrupting, I thought you were done, I apologize. But the counselor also admitted, didn't she, that he had indicated, the father had indicated that he was to be notified. And she promised that she would notify him.
The evidence is something to the effect of Mr. Baab asked to be notified if anything additional happened. Well, the evidence is clear that this is not an additional new threat of self-harm. This is
right. I know your argument. Your argument is that she saw this as something that already had happened, and there's no need to notify the father. But if he asked for her to notify him if there was any additional information, the fact that a mother called and said that she was concerned over him killing himself, and he admitted to her that he wanted to kill himself, whether that happened, after the original conversation with father or not, there was additional information, wasn't it?
No, I think you need to look. It's a new source of information, but I take issue with Appellee's characterization of just a new source of information that Mr. Baab and Ms. Schwendeman had already discussed. I don't think that that's a new threat. And I think that you need to look at Kim Mahoney's testimony because it confirms Julia Schwendeman's interpretation that this is not a new threat. So if you look at Kim Mahoney's testimony, number one, she doesn't even know what's in the text that DB was sending her son, because she testified that I never saw the texts, I never discussed with my son when they were sent. And so, Kim Mahoney, because she never saw the texts or knew when they were sent, and she never asked her son, she testified, I never asked my son when the texts were sent. She could not have relayed to Julia Schwendeman, these are new texts, DB is threatening to harm himself now.
Counsel, as it relates to Mahoney's testimony, did he not approach his mother, the child not approach her, coming home from school that day being upset about this idea that a friend of his was threatening to commit suicide?
I don't think that it was a friend necessarily threatening to commit suicide, but my interpretation of the testimony is that Kim Mahoney's son, at some point after school, came out of his room and, yes, was upset that he had received these texts from DB. But Kim Mahoney never saw the texts.
And then she calls the child, correct?
Yes, and so that's the other important key to this, is so Kim Mahoney calls DB, and so what, Kim Mahoney testifies that at some point in that conversation, I asked DB, you don't really, or I said, it was a question, you don't really want to kill yourself, do you? And DB's response, per Kim Mahoney, is I don't know.
And then she asks him to promise that he will not do that over the weekend, correct?
Right, she invites him to come and spend time with the family, I think over the upcoming Thanksgiving break, and she does. Will you promise me not to harm yourself over the weekend? And DB says yes.
And then immediately on Monday morning, she calls the school, correct?
No, so that's the other, I think, important fact to realize when because how Kim Mahoney interpreted DB's statements is important, because that's what she would presumably relay to Julia Schwendeman. So when Kim Mahoney and DB stop talking, what happens? Does Kim Mahoney call the police and say, I just spoke to DB, he's a friend of my son, and DB is threatening suicide? No, Kim Mahoney does not do that. She gets ready for work, and she goes to work. When she comes home from work that evening, does she call the police at that time? You would think that if I'm concerned that a teenager is imminently going to kill himself, I would contact the police. But she doesn't. She goes to work, she comes home, she goes to bed, and it's not until the next morning that she doesn't decide to call the authorities, she calls the school. And the purpose of her call to school is she wants DB's father's phone number so that she can call DB's father to see, to suggest that maybe he needs to get DB into counseling. Well, these are things that Julia Schwendeman and DB had talked about for the last 2 weeks, and in fact...
Counsel, let me interrupt for a second. So, in answer to her question, when did she call the school?
She called the school the next morning.
Okay.
And
that was Monday morning?
No, so...
I'm sorry, go ahead. I'm confused.
So, Kim Mahoney and DB spoke on the phone on a Thursday evening. When they're done talking, Kim Mahoney goes to work, she comes home, goes to sleep, and then it's the next morning, Friday morning, that she decides, well, I'm going to call the school to try to get Mr. Baab's phone number. And so she calls the school and she speaks with the school secretary and ends up leaving a message with the secretary, please have a guidance counselor call me. And then Julia Schwendeman then called her later, around noon on Friday. So they spoke. Kim Mahoney testified, I didn't think the situation was an emergency.
Because she had his promise that he wasn't going to do anything right now.
I don't know.
Although she called before the weekend was even begun, really.
Right, I mean, she did call the next day, but she testified that from talking to DB, I didn't think the situation was an emergency. She didn't call anyone right away, she waited until the next day, and then she spoke with ultimately spoke with Julia Schwendeman the next day. And then it was that Friday that DB was out of school. So I think that it's pretty clear from Kim Mahoney's testimony that she never viewed the situation to be an imminent threat, that DB was going to harm himself. And so that's not what she relayed to Julia Schwendeman, which is entirely consistent with Julia Schwendeman's testimony.
Now, Counsel, would you like to continue? You're at 3 minutes, or do you want to reserve the final 3 minutes?
I will reserve the final 3 minutes.
All right,
Thank you.
good, thank you.
Please support John Cameron for Appleby, Richard Baab. Mr. Hurt is asking this court to overturn the decision of the trial court based upon 3 things. The facts most favorable to Julia Schwendeman, not the facts most favorable to Richard Baab. A misstatement of the definition of recklessness. Mr. Hurt cites O'Toole for the proposition that a perverse disregard of known risk, that's not in Anderson. If I can clarify, the Ohio State Supreme Court in Anderson versus Maslin clarified the definition of willful, wanton, and reckless conduct. And Mr. Hurt would have this court imply he really kind of misstates it and makes it worse. He says in all probability that it would cause the injury in O'Toole. O'Toole does say that there must be a substantial probability of injury, but that's in the context of where only a statute, a code section, a policy was violated, where the conduct of the actor would not otherwise rise to the level of recklessness. The Ohio State Supreme Court clarifies in Anderson that that's what that language in O'Toole was all about. O'Toole quotes from Fabre. Fabre was a case where a police chief was getting sued because of the smoking policies that they had that somehow allowed a prisoner to have a lighter, and the prisoner intentionally set his mattress on fire, and the prisoner was suing the police chief. O'Toole, same thing. It was simply a violation of a policy.
Well, counsel, do you agree or not agree with opposing counsel's statement that the trial court misstated the definition of recklessness in the judgment?
The definition of recklessness from Anderson, which was the latest and most complete holding on this issue from the Ohio State Supreme Court, is that reckless conduct is characterized by the conscious disregard of or indifference to a known or obvious risk of harm to another that is unreasonable under the circumstances and is substantially greater than negligent conduct.
I understand that. I guess the question is, counsel is saying, or the appellant is saying, that the trial court misstated the definition in the journal entry. And my question is, do you agree or disagree that in the actual entry, the test for recklessness, the definition thereof is misstated, that there's an actual misstatement of the law as it exists?
I don't think it's a misstatement of the law. I think you could characterize it as maybe not the most artful, but it certainly gets the essence of recklessness. If there's a misstatement, it would be harmless error. It may not quote verbatim Anderson, but it gets the import of Anderson. As I said, if you look at the correct text, Julia displayed a conscientious disregard or indifference to Kim Mahoney's phone call. By her own testimony, she said she didn't think it was cause for concern, and she certainly took no actions other than to misstate the nature of the phone call to her assistant principal. And the only conversation she had in regards to the phone call was she said that that day she told her assistant principal about the phone call. But she told her assistant principal that Miss Mahoney had called up to complain that DB was harassing her son. Not that DB was considering suicide, not that any of the real gist of the phone call. There was a known or obvious risk of harm to another. Clearly, if a child is contemplating suicide, there is a risk that the child will carry it through. It was obviously unreasonable under the circumstances. All that Julia Schwindeman needed to do to discharge her duty was simply call up Rick Baab. We would not be here had she taken 5 minutes of her time to tell a child who is seriously considering suicide's father that the child is considering suicide. I don't know how anyone could say that's not unreasonable. And it's substantially greater than negligent conduct.
Does her failure to file the risk of suicide risk form play into this at all?
If I was trying to make my argument based upon her violating school policies, yes, it would. There was a duty at that point in time to do the risk assessment. There seems to be a debate as to whether or not a risk assessment is required in anything other than suicide. But at that point in time, yes, she would have been required to do a risk assessment. We aren't even holding her to that. We're simply saying you could have called the father. That's all that every single person that we deposed at Medina City Schools that we posed that question to all said the same thing. Yes, she should have called her. Julia Schwindeman has given 3 separate and distinct versions of the facts. She gave a version of the facts when she was first interviewed by the Medina Township Police and the Medina City Police. See, Julia Schwindeman never voluntarily told anyone about the conversation she had with Kim Mahoney other than the misstatement. It was only found out by accident. And when the police came to question her about it, she gave them a version of the facts, which, interesting enough, her statement says, as far as a suicidal threat, she said the night before, but unfortunately, anyways, go to the statement that he made to Kyle. I'm sure how far they go back, but they have been as recently as the previous day. So Julia acknowledges in her first statement that DB made a suicide threat to Kyle the day before. Phone call, and I apologize, my brief, by the way, probably through a teeny bit of confusion that I had a typo in it. It said that the conversation between Kim Mahoney and DB was on the 12th of November. It was really the 15th of November. Julia Schwindeman gave another entirely different version of the facts when she was given the opportunity to think about it and write a written statement to the police. A lot of stuff that wasn't in the initial statement of facts to the police somehow makes it into the second version of the facts. And then she gives a third version of the facts when she was deposed. There are multiple inconsistencies between her testimony, between the first, second, and third version of the facts. And what Mr. Hurt has done in this is he's picked and choose through the 3 versions of Julia Schwindeman's facts to try to find the ones most favorable to her. Ms. Schwindeman alleges to have had multiple conversations with multiple co-workers in regards to DB. However, the vast majority of these alleged conversations were never verified by the co-workers she allegedly had them with. I guess it really comes down to, if you look at the totality of the circumstances, Julia Schwindeman first discovered that DB was cutting in late August or early September of 2012. She was told by DB's IEP teacher that he was cutting. She had a duty at that point in time. Her fellow counselor, Stevie Beshire, said that she should have called the child's parent. She did. She didn't even see DB. She simply asked the IEP teacher to check in on him. She next became aware that he was cutting in late September, early October, when some girls came to her and told him that he was cutting and his father was abusing him. At that point in time, she should have called Rick. She didn't. She alleges to have begun counseling with DB. There's absolutely no documentation anywhere of her actually counseling with DB, but she presumably did. And then on October 23rd, DB, it comes to Julia's attention that DB is cutting again. And this time, Julia calls DB down to the office and actually calls Rick for the first time, 2 months after she discovered he was cutting. And Rick immediately, from his testimony, calls around and schedules counseling for DB. There seems to be a debate over when the counseling actually was scheduled for, but Rick's testimony was that he scheduled the first appointment he could get. He called 4 or 5 counseling agencies. He called everyone in Medina he could find. And he made the first appointment available.
We've got about 2 minutes and 30 seconds.
Okay. Fast forward. I'll skip over. On October 31st, Julie Schwindeman receives, is there any water? My mouth is, I can't talk.
I haven't drunk out of mine.
Thank you so much. Thank you for your kindness.
No problem.
I've already drank out of mine, so you know.
October 31st, new and different. DB is threatening suicide. Julie Schwindeman becomes aware of the threat of suicide and calls Rick and DB and Bill Roberts, the IEP teacher, into the school. And the testimony from Rick is that when they get there, Bill Roberts berates DB, asks him what he hopes to get out of this, tells him he's interrupting children who are trying to learn. Julia Schwindeman tells him that he could be prosecuted criminally if he continues to tell his concerns, his desire to commit suicide to other students. Rick gets frustrated, takes DB to Akron Children's Hospital. Mr. Hurt goes to great length as to all that went on at Akron Children's Hospital, so the truth of the matter is Julie Schwindeman had no idea what went on at Akron Children's Hospital because she never called them, she never asked for a release, she never ordered any of the medical records, she never followed up with Akron Children's Hospital. In fact, she never even saw DB again after he came back from the hospital. If you dig through her 3 different versions of the facts, one she says she had multiple meetings with him, but on deposition she admitted that she didn't meet with him at all. She never saw him again afterwards. And she did absolutely no follow-up. On November 15th, Kim Mahoney is home. Her son comes in crying and upset because he just got a phone call or a text from DB, and he's upset that DB is threatening suicide. Kim Mahoney immediately gets DB's phone number, gets on the phone with DB, and DB tells her, yes, I am considering suicide. I want to do it. I am really seriously thinking about this. As was stated before, Kim tries to keep everything positive. She tries to invite him over. She tries to give him things to look forward to so he won't commit suicide. And she extracts a promise that he won't kill himself that weekend. Friday morning, first thing. You know, it's interesting that that Mr. Hurt seems to try to impose some kind of duty on Kim Mahoney, who had no duty, that he doesn't apply to Ms. Schwindeman, who had a duty. No, she doesn't call the police immediately because she isn't sure and she's got a promise. She calls up the school the next morning and tells Mrs. Dwyer, the secretary who answers the phone, that DB wants to kill himself. I want to talk to the counselor. Can you please give me his father's phone number?
I'll let you wrap up, but you are now over time.
Okay.
But if you can wrap it up succinctly for us.
Succinctly is it's in the briefs, what transpired between Kim Mahoney and the conversation between Kim Mahoney and Julia Schwindeman. As long as you look at the facts most favorably construed to Rick Baab, not the facts construed most favorably to Julia Schwindeman, it's really clear, that conversation. And I thank you very much.
Thank you, Attorney Cameron. Attorney Hurt, you have 3 minutes.
Thank you. I obviously, I'll leave it to the reading of the briefs, but I disagree with much of Mr. Cameron's characterization of the evidence and the timeline. What I would like to touch on is another error that Mr. Cameron and I think the trial court made here, is the focus on the risk assessment per the administrative guideline that the superintendent had issued. So the first time that Julia Schwindeman knew, not that Devin was threatening to harm himself, but that he had informed some of his classmates that he was thinking about doing that, was October 31st. And so that is the first time, arguably, that a risk assessment should have been done. But that is also the exact same day that Mr. Baab took DB to Akron Children's, and Akron professionals at Akron Children's did the risk assessment. And for Mr. Cameron to say that there was no follow-up after that by Julia Schwindeman is also untrue. The record is pretty clear from both Julia Schwindeman and Mr. Baab's testimony that Julia Schwindeman called Mr. Baab the very next day to make sure that he had taken DB to Akron Children's for the risk assessment and to find out what the outcome of that was. And the evidence is also clear that Mr. Baab told Julia Schwindeman that the risk assessment resulted in findings by Akron Children's personnel that DB was not a suicide risk. And so to say that there was no follow-up from Julia Schwindeman is not accurate. And to go back to, again, one of the earlier points that I made, that Mr. Cameron, again, I think incorrectly interprets the evidence, there is no time frame that's available for the text that DB sent to Kim Mahoney's son. Again, Kim Mahoney's son never testified about the text. Kim Mahoney testified, I didn't see the text, I don't know when they were sent, I don't even know what they said, I never asked my son when the texts were sent. And so arguably, even the content of those texts is inadmissible hearsay, because all it is Kim Mahoney saying, this is what my son said were in the text. Kim Mahoney never saw the text. And to say that I'm trying to impose a duty upon Kim Mahoney to call the police, that's not what I'm implying, and I don't want to leave you with that impression. What I'm saying is that what we need to look at is what's going on in Julia Schwindeman's mind. Was she conscious that not telling Mr. Baab about the phone call from Kim Mahoney would in all probability result in DB killing himself? And one of the clues to what's going on in Julia Schwindeman's mind is, well, how did Kim Mahoney interpret her conversation with DB? And it's clear that Kim Mahoney testified that I didn't think the situation was an emergency. I asked DB whether he really wanted to harm himself, and DB said, I don't know. And it's indicative of the fact that Kim Mahoney never called the police that evening or the next day. That's an indication that she did not view the situation as an emergency, which is what she testified to. And so I think that even if Julia Schwindeman misinterpreted the urgency with which Kim Mahoney thought, but maybe didn't express as to what the situation was with DB, again, the focus needs to be on, well, what's going on in Julia Schwindeman's mind? Was she conscious that that not telling Mr. Babb about the phone conversation would in all probability result in DB harming himself. And she was adamant that no, from my conversation with Kim Mahoney, all I learned were things that I had already discussed with Mr. Babb, and Mr. Babb told me that he had arranged for counseling for DB in the middle of November, which is precisely when Kim Mahoney called.
Mr. Hurd, thank you, but your time is up as well.
Thank you very much.
Thank you both for excellent arguments today. The court will take the matter under advisement, issue a decision in due course. Clerk of Courts will certainly mail you a copy of the decision once it's released. And you can keep an eye on the Ohio Supreme Court website because we also post our opinions there. Thank you both for your presentations today.
Thank you, Your Honors.